Won't be much time to rest and relax this holiday season for Donald Trump and his legal team. The 4 times indicted former president is in the middle of a very complicated legal situation as he faces 91 criminal charges related to his conduct before, during, and after his presidency. A civil fraud trial in New York threatens the future of his real estate empire, while a different civil suit holds him liable of sexually abusing the writer and columnist E. Jean Carroll. Carroll is also suing Trump in a second defamation trial over comments that he made on CNN in May about her. Late last night, Donald Trump filed a brief to the D.C. Court of Appeals, continuing to assert that he is immune from prosecution for acts he committed while president, specifically for his role in questioning the results of the 2020 election. Of course, the allegation is not that he questioned the results of the 2020 election. Anybody's entitled to do that. Is that he did something to try and overcome those results. But the immunity argument is the argument he's making in hopes of getting Jack Smith's criminal election interference case against him dismissed. It's an effort that also has the potential to upend Fani Willis's sprawling election interference case in Fulton County, Georgia, not to mention the fact that if Trump succeeds in his claim of immunity, it could reshape our collective understanding of the powers of the presidency. Meanwhile, the Colorado Supreme Court ruled last week that Donald Trump is ineligible to appear on that state's primary ballot based on the disqualification clause in Section 3 of the 14th Amendment of the Constitution. Trump's lawyers have indicated that they will appeal that ruling. Trump has until January 4th to file an appeal to the Supreme Court, one day before Colorado's Secretary of State, with whom I will speak in a moment, is due to certify the candidates for the primary ballot. Filing an appeal will enact a stay of the Colorado Supreme Court's order, meaning that Trump could potentially remain on that ballot until the Supreme Court of the United States itself resolves the matter one way or another. It's an historic decision that could completely shake up the 2024 presidential race, which officially kicks off in a few weeks with the Iowa caucuses. The decision is already causing turmoil in Colorado. The state GOP has floated the idea of switching from a primary to a caucus, a plan that would face major legal and logistical hurdles, with only about 2.5 months left before the state is scheduled to hold its nominating contest. Immediately after news of that ruling in Colorado broke, by the way, violent rhetoric online surged, and members of the Colorado Supreme Court received a wave of violent threats on social media and other websites, according to a report by the nonprofit, nonpartisan organization Advance Democracy. In one pro-Trump online forum, one user posted, quote, "What do you call 7 justices from the Colorado Supreme Court at the bottom of the ocean? A good start." The FBI is now getting involved as well, saying in a statement that they're working with local law enforcement and will, quote, "vigorously pursue investigations of any threat or use of violence committed by someone who uses extremist views to justify their actions, regardless of motivation," end quote. Colorado is a test case for a constitutional challenge that has never been applied to a former president before, let alone the current frontrunner for the Republican nomination. Like many other states, Colorado is supposed to be preparing to administer its primary, but a lot of things remain unclear. This is uncharted territory. It adds even more uncertainty to what is already shaping up to be the most uncertain election season in modern history. Joining me now is the top election official in Colorado, Jena Griswold. She's the Secretary of State of Colorado. She's the chair of the Democratic Association of Secretaries of State. She's a champion for democracy and a good friend of our show. Secretary Griswold, thank you for being here.
Thank you for having me.
We had a conversation about this very early on, and you, like every Secretary of State in the country who is responsible for running elections in your state, had the same response, and it was that it was not likely going to end with you. In other words, while one could on paper say that you are the final arbiter of these things, you knew full well that this would go before the courts, and it has now gone before the courts 2 times in Colorado. It's gone before the courts in New Mexico, and it will go before other courts as well. Where do you stand right now on what has been decided? How do you move forward in Colorado based on what has happened?
Well, 2 courts have looked at whether Donald Trump is disqualified and whether he engaged in insurrection. Both have determined at this point that he did engage in insurrection. And then the Colorado Supreme Court, of course, has disqualified him from the Colorado ballot. And Allie, I agree with the Colorado Supreme Court. I've said, for quite some time that Donald Trump has incited the insurrection, and there shouldn't be a loophole for inciting insurrection for the presidency. So just like you, we'll wait to see if an appeal is filed to the United States Supreme Court and whether the United States Supreme Court decides to intervene in the case.
I want to ask you about something. Judge Luttig and Lawrence Tribe have been at the forefront of this discussion for a long time. They always felt that the Colorado case was the one that was probably the most important. Judge Luttig was on the show yesterday taking exception to some of the discussion that's going on in the United States to say this would be unsatisfying. To have Donald Trump disqualified for this legal matter, the interpretation of Section 3 of the 14th Amendment, would be less satisfying than to have Donald Trump on the ballot and have people not elect him as president. Judge Luttig said those are separate and unrelated arguments. The legal matter needs to be pursued as a legal matter.
That's right. My job is to follow the law and uphold the Constitution. And when there's big questions about whether something is constitutional or not, it's appropriate to go to the courts. At the end of the day, we are only at this point because Donald Trump tried to disenfranchise Americans across the country when he tried to steal the presidency in 2020. That was not satisfying. He lost that election. And so I think the idea that we move forward and just ignore what happened throughout 2020 and then the attacks on democracy afterwards is also very dangerous. We know that he is a threat to this country. He is a threat to voting rights. He's a threat to the right to choose. He's the threat to the stability of this nation. And the idea that we have an election and he loses and accepts the results if he does lose is not going to happen. We are very likely going to be in a similar situation that we were in 2020.